You know, if someone carelessly causes a car crash and breaks your arm, the legal path to compensation is, well, it's pretty clear-cut. But what happens when the scars are entirely on the inside? Welcome to this explainer. Today we're diving into a genuinely fascinating and honestly super complex area of UK law. We're looking at exactly how the justice system tries to quantify and compensate emotional trauma. It's a real legal maze of psychiatric injury.
We all naturally assume the law compensates for physical harm, right? But today we're asking a totally different question. What actually happens when the injury is completely invisible? Can you sue for shock? It's a concept that has literally challenged judges for well over a century. They're constantly forced to balance this deep, genuine empathy for traumatized victims against a very real, very practical fear of just bankrupting the whole system with limitless claims.
So, here's our roadmap for today. First, we'll define psychiatric injury claims. Then, we'll look at primary versus secondary victims, break down the strict Alcock criteria, discuss rescuers and bystanders, compare sudden versus gradual shock, and finally, summarize the landscape of legal liability.
All right, let's jump right into part 1, defining psychiatric injury claims.
So, your very first hurdle here is proving that the emotional harm actually meets the strict legal definition of an injury. You can't just walk into a courtroom and say, hey, I was deeply upset. It doesn't work like that. Ordinary grief or a temporary shock, they just won't cut it. The courts require absolute, rock-solid medical proof of a severe, recognized illness, think PTSD or reactive depression. You need evidence showing this condition genuinely disrupts your life, often preventing you from working, which is why these claims so often involve compensation for lost earnings.
Now, it wasn't always this way. Historically, judges were, frankly, highly suspicious of these kinds of claims. Back in 1901, with the Dooley v. White case, victims only got compensated if they feared for their own personal safety. Picture a bartender absolutely terrified when a horse and cart literally crashed right into our pub. It wasn't until 1925, in a case called Hambrook v. Stokes, that the law slowly started to expand to include the trauma of fearing for a family member's safety.
Which brings us to part 2, primary versus secondary victims.
This is the biggest fork in the legal road, formally established in the 1995 House of Lords case Page v. Smith. Who you are in relation to the accident basically changes everything. The law divides everyone into two distinct camps. If you're a primary victim, meaning you were directly involved in the accident, the path is pretty straightforward. You just need to prove the defendant was negligent. But if you're a secondary victim, meaning you merely witnessed the horrific event, well, the law intentionally makes it incredibly difficult for you to make a claim.
This flowchart here brilliantly illustrates that legal gauntlet. The decision process for a secondary victim is incredibly rigid and, honestly, quite unforgiving. You literally have to pass every single step of a strict set of criteria. If you fail even one specific requirement as a secondary victim, that's it. Zero liability for nervous shock. The court just closes the door.
Let's move on to part 3, the strict Alcock criteria.
So what are those specific requirements for secondary victims? Well, they were forged during one of the absolute darkest days in British sporting history. Following the devastating Hillsborough Stadium disaster in 1989, where 96 football fans tragically died due to police negligence, hundreds of devastated relatives suffered severe psychiatric injury. To handle this unprecedented situation, the House of Lords created strict control mechanisms to limit claims. This became known as the landmark case of Alcock.
To succeed as a secondary victim today, you've got to pass these 3 incredibly strict hurdles, known as the Alcock criteria. First up, you need proof of close ties of love and affection with the victim, which usually means a spouse or parent. Second, you have to be physically present at the scene or its immediate aftermath. And third, you must witness it with your own unaided senses. So watching it on live TV or hearing about it on the phone doesn't count. Plus, on top of all that, you have to prove that a person of reasonable fortitude would have suffered that exact same injury.
You can really see how rigid these rules are in reality when you compare 2 specific cases. In McLaughlin, a mother who arrived at a hospital 2 hours after a crash to find her family untreated and covered in oil, she was deemed to be in the immediate aftermath. But tragically, in the Alcock case, relatives who arrived at a makeshift mortuary 8 hours later to identify their loved ones, legally, they were considered too distant in time. Their claims were completely denied. It's a very harsh, very artificial legal boundary.
That brings us to part 4. Rescuers and bystanders.
So, what about people who jump in to help in an emergency, or those who just happen to be standing nearby when disaster strikes? Well, the law actually makes a fascinating exception for physical heroism. If you crawl into a terrifying train wreck to help survivors and you put yourself in physical danger, like what happened in the famous 1967 Chadwick case, the law treats you as a primary victim. You get to bypass all those strict Alcock hurdles. And why? Because public policy dictates that we should absolutely never discourage people from stepping up to rescue others.
However, the rules shift dramatically when it comes to professional rescuers. In the White case, police officers who helped with the rescue operation at Hillsborough filed claims for PTSD. But because they weren't in actual physical danger themselves, the courts classed them as secondary victims. This meant they had to pass those nearly impossible Alcock criteria, which, unfortunately, they couldn't do.
The courts drew a really hard line here, basically for the sake of fairness. The judges explicitly stated that it would be morally unacceptable to award financial compensation to professional police officers for their trauma, while simultaneously denying compensation to the grieving families of the deceased, who had just arrived a few hours too late.
And what if you're just a bystander watching a horrifying event unfold? Say, for example, a man witnessing the massive Piper Alpha oil rig explosion from a nearby supply ship, but he doesn't actually help in the rescue. Well, you won't be compensated. Unless a bystander somehow meets all those strict Alcock hurdles, which is incredibly rare, the law firmly views them as outside the zone of compensation.
All right, moving to Part 5, Sudden versus Gradual Shock.
Let's examine the timeline of the trauma itself, because this is another massive legal tripwire for claimants. The mental injury absolutely must stem from a sudden, horrifying shock, and this rule leads to some truly heartbreaking legal outcomes. Take the case of Sion versus Hampstead. A father watched his son slowly deteriorate in a coma over 14 days due to medical negligence. But because it was a gradual appreciation of his son's decline, rather than a single sudden shock, the court completely denied his claim.
Now, the law does occasionally bend, if the facts are exactly right. In the Walters case, a mother endured an uninterrupted 36-hour cascade of horror, from a negligent misdiagnosis of her baby to a sudden seizure, and finally, having to turn off life support. In this specific instance, the judges ruled it wasn't gradual. They viewed it as a single, uninterrupted, sudden appreciation of a horrifying event, which allowed her claim to actually succeed.
Finally, Part 6, Summary of Legal Liability. Let's wrap up this explainer by zooming out and looking at the bigger picture. Over a century of complex case law, from Dulio back in 1901 all the way to Walters in 2002, shows us how judges have meticulously built this artificial framework just to cap the number of claims. They've essentially engineered a system where primary victims and heroic rescuers are protected, while secondary victims face a near insurmountable wall of criteria.
And surprisingly, this framework can sometimes yield outcomes that feel, well, a bit paradoxical. For example, the law can sometimes seem more protective of property than actual people. In Adia v. British Gas, a woman was allowed to claim for psychiatric injury simply from watching her house burn down due to negligence. Similarly, near missers, people who aren't physically hurt but narrowly avoid being crushed or hit, they're treated as primary victims. They can claim easily, no Alcock test required.
So, I want to leave you with this thought to ponder. The rules governing psychiatric injury are undeniably harsh. They're highly technical, and sometimes they feel completely arbitrary depending on a matter of hours. But given the absolute necessity of preventing the floodgates of litigation from totally overwhelming the justice system, are these rigid tests the only practical way forward? Thank you so much for exploring this legal maze with us today.